Welcome to the Bald Brad Show. Our story today is dealing with everything you need to know about the Mississippi abortion law that may or may not be upheld by the United States Supreme Court. Now, many times these Supreme Court cases and hearings are very confusing, and my goal here through this episode is package it and present it in a simplified manner so that we can all make sense on what the heck is going on. Now, this comes from a multitude of sources like the Daily Wire, the Washington Post, the New York Times, and I also want to give an update. We are doing a live stream tomorrow here on the Bald Brad Show. It will be a Q&A, so come hang out at 5 p.m. Pacific Standard Time, again, here on the channel at the Bald Brad Show. Bring food, drinks, so that we can have a good time together. And with that being said, the Supreme Court heard arguments concerning a case regarding a Mississippi abortion law that could have massive implications for pro-life laws around the country, as well as pro-choice advocates. The case, Dobbs v. Jackson Women's Health Organization, concerns a 2018 law in Mississippi that bans most abortions after 15 weeks of pregnancy. As the law stands now, Roe v. Wade and the decisions that came after it hold that states have to allow a woman to be able to get an abortion up to the point of viability, or in other words, when the baby can survive on its own outside the womb. Now get this, most states hold this mark at around 20 to 24 weeks, folks. If you want to know what a baby looks like at 20 to 24 weeks, this is what it looks like. And they want to be able to kill this damn thing up to 20 to 24 weeks, meaning cutting off its head, cutting off its limbs, and then extracting it out of the woman. This is what the left wants. Well, if Mississippi is successful and the law is upheld, it would directly go against precedent already set by the 1973 Roe v. Wade decision. Mississippi Solicitor General Scott Stewart was the first to present on Wednesday, outlining the state's points for upholding its law. The state's argument is that each state should be able to decide its own abortion laws. The Supreme Court agreed to consider the question of whether all pre-viability bans on abortion are unconstitutional. Now, this is massive, folks, because we can ultimately get rid of Roe v. Wade, Casey, and all these other precedents that were put in place by the Supreme Court in prior years. Well, a main topic of discussion during the arguments was the doctrine of stare decisis. The New York Times reported this: the phrase, which roughly translates as to stand by things already decided, refers to a doctrine under which the court should stand by its previous decisions and hesitate to overturn precedents. Now, my problem with this is the Supreme Court in the past has been wrong on certain decisions that it's made, and it's had to overturn them, and rightfully so. Roe v. Wade is a prime example of that, in which the Supreme Court needs to fix its mistakes that it made in the past. Some of them were interested in knowing what a different standard might look like rather than the one set by Roe and Casey, meaning we're talking about viability here. If we can't come to a consensus on when a baby is a baby, when a baby is viable, when a human being is viable, I'm using those words very specifically because the left does not believe that a baby inside the womb is not a baby. It's not a human life. They refer to it as a cluster of cells. They don't think it's a living thing, folks. Okay, so if we can find another argument that's not talking about viability, then we might be able to move forward here in overturning Roe v. Wade or Casey, or even doing an own separate thing that's totally different than Roe v. Wade and Casey. Well, Justice Clarence Thomas, who has been extremely outspoken about his desire to see Roe v. Wade overturned in the past, had this to say. On Wednesday, he asked Stewart, if we don't overrule Casey or Roe, do you have a standard that you propose other than the viability standard? So what he's trying to do here, what Thomas is trying to do is go outside of the scope of Roe v. Wade and Casey and find a different result, a different standard that may be used to move forward with this abortion case or law. Well, after a few comments, Stewart responded, I would say if the court were not inclined to overrule Casey, the choice would be undue burden standard, untethered from any bright line viability rule. They also discussed how the alleged right to an abortion has to do with a woman's liberty. And Rickleman argued that pregnancy shouldn't be supposedly forced on a mother by the state. Now, this is an interesting argument here in terms of liberty that the left is pointing towards, because there's more like modern day liberty, and then there's liberty that we would expect to hear from the founders and from the framers of the Constitution in this great nation. And I want to talk about both right now. So in modern politics, liberty is the state of being free within society from control or oppressive restrictions imposed by authority on one's way of life, behavior, or political views. Thus, liberty entails the responsible use of freedom under the rule of law without depriving anyone else of their freedom. So this is more so of a leftist argument here on how they would describe liberty in their terms. Of course, they've construed it and manipulated it to fit their narrative. What I find interesting here, and the only way that this type of argument could work is that we don't have two sides of liberty here, meaning that we don't have the liberty for the mother, and we don't have liberty, or we don't have liberty for the child. Only one of them is going to have the liberty. For the left to make sense of this type of liberty, they have to remove that liberty from the baby and not identify it as a life, so that we're only looking at one standard here, one singular person, an individual whose liberty would be taken away through the government. Well, John Locke said this, and this is more of the revolutionary 1690 version of where the framers and the founders got their idea of what liberty was. Locke said this in his second treatise of government, quote, "But though this be a state of liberty, yet it is not a state of license. Though man in that state have a uncontrollable liberty to dispose of his person or possessions, yet he has not liberty to destroy himself, or so much as any creature in his possession, but where some nobler use than its bare preservation calls for it." Hear this: the state of nature has a law of nature to govern it, which obliges everyone and reason, which is that law teaches all mankind, who will be but consulted, that being all equal and independent, no one ought to harm another in his life, liberty, or possessions. Look, even if you were to split that and manipulate it, there are two liberties that are given. There's a liberty to the mother and a liberty to that human being. And no one shall harm its life, health, liberty, or possessions, folks. So hopefully you're seeing now the manipulation that the leftists have done to try to cater to their argument of how a woman's right to abortion should be there. I've looked and I've done research, is why I've held off on doing this story and why I didn't do it yesterday. I've been trying my darndest to look at the Constitution, to look at the Declaration of Independence, the Founding Fathers' words and documents, to find where a woman or anybody has the right to an abortion. I haven't found it. If you can all find it, you let me know. But there has to be some serious finagling done to make sense of the pro-choice argument. Well, the different justices had kind of their own way of tackling these arguments and kind of wanting to come to some sort of opinion themselves. And so let's kind of break that down on what each justice had to say and what their arguments were. Justice Amy Coney Barrett, who was put in place by Trump, discussed abortion and the ability to surrender a child safely under safe haven laws across the country, which can provide women with options other than becoming a parent. The left don't want to look at that. The left don't even want to give the pregnancy a chance at all. They just sit there and want to chop up this baby and throw it in the trash can. But Amy Coney Barrett saying, look, there could still be viability. That child could still be born. If you don't want to take responsibility of that child, we have other avenues to where that child can be viable, where you can give birth to it and it could still have its chance at life, liberty, and the pursuit of happiness. Justice Samuel Alito asked about viability and pointed out how people on both sides of this debate have said it's a line that doesn't make sense. And Alito is very interesting in his thinking here, because it doesn't make sense. Why are we stopping at 20 to 24 weeks? Why is that different than 19 weeks? Or in other words, why is the 15 weeks different than 14 or 16? What are the differences between? And that's something the left doesn't want to look at. They don't want to look at a week by week basis on how this baby has evolved and formulated into being a human life. Now, if you were to talk to pro-life advocates as well as myself, is that we believe life begins at inception. When that sperm hits that egg, there's a separate DNA. Everything is different. The strands, it's a separate human life that has the right to pursue that life, liberty, and again, pursuit of happiness. Pursuit of happiness. This is kind of where Alito's going. Justice Samuel Alito asked about viability and pointed to how both sides of this debate have said it's a line that doesn't make sense. He goes on, the pro-abortion side said that the viability line works because of the separation between the fetus and the woman, saying that philosophical arguments are kept out of the discussion. A back and forth took place between Alito and Rickleman regarding the standard of viability. Alito said, will you agree with me at least at that point that a woman still has the same interest in terminating her pregnancy after the viability line has been crossed? So depending on what the viability is, depending on the individual, say it was 16 weeks, they would still be on board to ultimately killing that life, killing that baby, even after the viability of the standard of 16. And that's kind of where the direction he's going with here. Rickleman responded, yes, Your Honor, but the court balanced the interest, and in ordering the interests at stake, Alito said, look at the interest on the other side, that the fetus has an interest in having a life, and that doesn't change, does it, from the point before viability to the point after viability. And this is where I think Alito's attributing to the original philosophy of the founders, and also John Locke here, Montesquieu and Rousseau, where everybody has the chance to life, natural order, a God-given right. How, for example, I just want to talk about natural rights here because the left doesn't always believe in natural rights, and they're trying to attribute this to a natural right that was given under God, which they ultimately don't believe in God. Let's break it down very simple. A natural right, like the Second Amendment, you have the right to defend yourself, right? That was given by a higher being, higher than the government, meaning God. Well, if you were to look in nature, an animal will ultimately defend its own life, its family's life, and its property. That would be an example of a natural right given by God, our creator. And this is where I think Alito's kind of going with it. If you look at the original documents of life, liberty, and the pursuit of happiness, you have a right to interest. You have a right to pursue your life. You have a right to pursue liberty as well as happiness. So this goes a lot deeper in this questioning than kind of meets the eye. Rickleman answered, in some people's view, it doesn't, Your Honor, but what the court said is that philosophical differences couldn't be resolved. And what he's talking about here is the philosophical differences on what interest is, liberty, and also viability. Justice Brett Kavanaugh pointed to the concerns regarding states' rights and the difficult topic of abortion itself. Kavanaugh said the other side says, though, that there are two interests at stake, that there's also the interest in fetal life at stake as well. And your belief, you say that the existing framework accommodates, that's your words, both the interest of the pregnant woman and the interest of the fetus. And the problem, I think the other side would say, and the reason this issue is hard, is that you can't accommodate both interests. You have to pick. That's the fundamental problem, and one interest has to prevail over the other at any given point in time. And that's why it's so challenging, I think. Well, Kavanaugh also added, when you have those two interests at stake and both are important, as you acknowledge, why not? Why should this court be the arbiter rather than Congress, the state legislatures, state Supreme Courts, the people being able to resolve this? In other words, why are we leaving it up to the Supreme Court to make this kind of decision? Granted, the Supreme Court kind of screwed themselves going back to the 70s and even before on hearing these abortion cases and not just leaving it up to the states to decide. So they kind of dug their own grave here, and now they're going to have to dig themselves out of it. But the court's 6-member conservative majority seemed divided about whether to stop at 15 weeks, for now at least, or whether to overrule Roe entirely, allowing states to ban abortions at any time or entirely. Chief Justice John Roberts Jr. was the leading voice on the right for a narrower decision. The thing that is at issue before us today is 15 weeks. So they keep coming back to this viability, and this is what John Roberts is talking about. He repeatedly questioned whether the viability was crucial, saying that Justice Harry A. Bluckman, the author of the majority opinion in Roe, had called the line arbitrary in his private papers. Chief Justice Roberts added that much of the rest of the world has similar limits. Assuming the three most conservative members of the court, Alito, Thomas, and Gorsuch, are prepared to overrule Roe entirely, what would need to happen is Chief Justice Roberts would need to attract at least 2 votes from a narrower opinion, one upholding the Mississippi law, but not overruling Roe in so many words, to be controlling. But the most likely candidates, Kavanaugh and Barrett, said little to suggest that they were included towards the narrow approach. The court's 3 liberal members, Breyer, Kagan, and Sotomayor, were adamant that Roe should stand. And I don't know if you caught, but one of the justices there, one of the liberal ones, I think it was Sotomayor, said that a baby was brain dead in the womb. And this is nuts. So we all know where she stands on this whole thing. But should Roe be overturned, at least 20 states, folks, will immediately or in short order make almost all abortions unlawful, forcing women who can afford it to travel long distances to obtain the procedure. Now, many of you don't know, but up until my mid to late 20s, I was pro-choice. like hardcore pro-choice, and then now I am pro-life. And you know who is able to make that shift for me, which was a big shift in my political views and my morality, was Ben Shapiro. And some of you might have that question, well, what was the deciding factor? What was the deciding factor for you to go from pro-choice to pro-life? And it was the understanding of life. And when I recognized it being a life, and folks, it doesn't take much research here, and that was my fault at such a young age, and I still am young, but at a young age of not doing the research on when a life was. Folks, it doesn't take that many pictures to look at a baby in the womb and go, that's a human being. It doesn't take much looking at they have a separate DNA, a certain heartbeat, a certain brain cognitive functionality at a certain period. So when you look at that, you go, this thing is being chopped up. This is a human being. This thing has, I shouldn't say this human being has feelings, has emotions, has all these things. It is a separate life, but that left doesn't look at it as a life. And that's kind of where Kavanaugh's coming here in his argument saying, look, how are we going to come to a middle ground if we don't even agree on viability? If we don't even agree that this is a life, somebody has to win here and somebody's going to lose. There's really no middle ground. And the left will not recognize it as a life. The left does not look at a baby inside the womb, even at 24 weeks. Some of them, even when the baby is fully developed, I'm not talking about head and hair and the whole shebang, they still think that thing should be chopped up right before it comes out of the womb. Say you're literally giving birth and this thing is coming out, this baby is coming out. They still think even at that point that it should be chopped up. So Mississippi's a little bit different here. They're making that limit 15 weeks for abortion, but they're ultimately trying to get rid of abortion altogether. Let's be honest, that's what's going on here. And I think as somebody that's pro-life, abortion needs to be done away. But that is everything, folks, that you need to know with what's going on currently with the Supreme Court case, this Mississippi abortion law that's taking place right now. Now, I will continue to update you on what's going on with the different arguments, but this is fascinating because you have people like Alito that are trying to make that deviation away from Roe v. Wade and Casey cases and trying to find maybe another argument that could be utilized here, such as interest, liberty, and going towards that pathway and maybe making and upholding this Mississippi law here at 15 weeks or getting rid of Roe v. Wade altogether. We have to see. We won't know the decision here, the dissents, the opinions, probably until July, June of next year, 2022, maybe earlier, but most likely we're looking at another 6 to 7 months here before we hear anything from our Supreme Court. But folks, again, I will keep you updated. I look forward to seeing all of you tomorrow, Friday, December 3rd at 5 p.m. Pacific Standard Time here on the Bald Brad Show to do a fun Q&A, talk about politics, talk about current events and culture and everything that's going on in the United States because there's a lot of craziness. With that being said, folks, make sure you like and subscribe to this video, share it with your friends and family all over social media, and I will see you later here on the Bald Brad Show.